So I think we've started now.
Yes.
Hello.
Hello.
And welcome to a webinar on how to protect video game intellectual property, or IP. Just as some housekeeping, hopefully everyone is now muted. But if you do have any questions, we're thinking write them in the chat and then we'll try and address them at the end. Or if there's a really important question, or you need to tell us anything else, like our mics aren't working or we're on the wrong window or something, please just put that in the chat as well. And we're also going to record this webinar, and there are some slides that you're able to download, and we're hoping to distribute the game itself as well, so you can play that, but we'll just see if we're able to do that. And today we have three presenters. There's myself, I am James Birch. I'm a trainee patent attorney and a hobbyist game developer. So I make games basically just for fun. I do the odd game jam, that kind of thing. And then we have Pam. Pam is a partner at Marks & Clerk, a chartered UK and European patent attorney, a registered Singapore patent attorney, and a European design attorney. And finally, we have Eric. Eric is a part-qualified trademark attorney, and he also advises on copyright and design. So this presentation should hopefully be slightly unusual, because as you can see, this window here is not Microsoft PowerPoint. It's actually a video game that I created in the Godot, or Godot if you prefer, game editor or game engine, with input from my colleagues. One thing that I didn't develop though, unfortunately, is telepathy. So there may be parts of the presentation where my colleagues have to tell me to move the character forwards or back. Please just excuse that. And then the plan for the webinar is first to introduce why you would be interested in intellectual property, then to cover some of the basics of the different types of intellectual property, and then to show a whole load of tailored examples, so tailored to the video game industry, of things that you could protect with intellectual property. And then we'll do the questions at the end, and hopefully there'll be lots of good questions. So starting up the game, here is my controllable character. I am moving this character in real time. And as you can see from the user interface up at the top, we have an IP skill bar. This will progress as we go through the levels of the game. We'll get more bucks. We also have an intellectual property value, like score type label. And this will go up every time we pick up one of these coins, which will hopefully replicate what will happen to your intellectual property in real life. And the way that we'll be, or our character will be learning about the intellectual property system, is that they'll be running through the level and they'll run over these signs. And whenever they run over a sign, some information will come up, and we'll just be going to the end of the game. So here is, what I was going to say next is, as you'll all be aware, a video game is essentially just a bundle of intellectual property rights. In fact, intellectual property is so important for video games that people often talk about developing new IP as a shorthand or a different way of saying developing a new video game. And additionally, the video game market is really fast moving and it's really competitive. So any leg up you can get over your competitors is well worth having. And intellectual property is one of these legs up that you can get. So in particular, you could use intellectual property to secure loans or to promote investment from others into your company, because investors can see that you have a valuable asset. It can also be used to distinguish yourself in the marketplace by protecting your recognizable branding, and this corresponds to preventing others from using your creations as well. It can also help with licensing and enable you to generate a stream of income. This might be licensing your intellectual property abroad or to a different video game platform, Steam, Nintendo Switch Store, or whatever else. And it could also help with promoting cross-licensing and collaborations. So an example I'd like to give for this is the licensing of the Zelda intellectual property from Nintendo to Brace Yourself Games. And this was for the crossover game Cadence of Hyrule, which incidentally I really like. And another example would be all of the cross-licensing that happens for Super Smash Bros. And we hope that if you use the intellectual property system correctly, you too can be as happy as the lady here. So there are a few different types of intellectual property rights. This presentation is going to focus on patents, trademarks, designs, and copyright. There are a whole load of other intellectual property rights written here, all grayed out, but they're really out of the scope of this presentation. Additionally, just for brevity, we're going to focus on the UK and Europe mostly, but of course you need to think about where your biggest market is for where your intellectual property rights will be most effective. So I'm now going to just run to the end of the level, and Pam can explain in more detail some of the other types of intellectual property rights.
Thanks, James. Yes, hello everyone. So yes, if the character moves to the first section here, this is just another way of looking at different types of intellectual property that might be relevant to video games. So here we've just split them into two categories. One is registered rights and one is unregistered rights. So an advantage of the registered rights would be that there is more well-defined protection. So you can look at a patent and really determine, you know, what is it that that company has protected. So you kind of can gauge where you stand on that. Another advantage of the registered rights is that actually if somebody did infringe your rights, you wouldn't have to prove that they copied you. Independent creation would also be covered if it performed the same things, and if it fell within the scope of your patent or your registered design or your trademark rights. So you don't actually have to prove copying. Whereas for unregistered rights, they have different advantages. And in fact, the pros of one are the advantages of the other. So for unregistered rights, the scope of protection is a bit less well defined because there is no register where you can look up what someone has copyright in. It's a bit harder to find out actually what that copyright might be and to what extent it might exist. So that's a negative for the registered rights. The main advantage of the unregistered rights is that they are free. You don't have to do anything in order to get these rights. You don't have to apply to an intellectual property office. They arise automatically as soon as you create something new. And that is really the disadvantage of registered rights, which is the fact that unfortunately registered rights are not free. They do cost money and they can be quite involved and take a fair bit of time and effort to actually go through the application process and get something registered at the end. So the pros of one are really the cons of the other, but both have their place, and together they can help provide a kind of intellectual property arsenal that you can have to protect yourself and gain some of the benefits that James mentioned. Okay, if we move the character forward. So really, we'll take a closer look at just some of the key points that need to be thought about in terms of the different types of IP and really what do they protect. So in terms of patents, many of you may be aware that they protect something that's new, that's novel, and that is clever or inventive or not obvious in view of what's gone before. So that's an additional hurdle. As well as never having been done before, it has to be something more than a simple modification of what's been done before in order to be patentable. And there are specific exclusions that are listed here. The relevant ones anyway to this talk are listed here. So you can't get patent protection for the rules for playing a game, for example, or for computer programs, but only in as much as your innovation relates to those things kind of in isolation. So it would really depend on what does your computer program do? What's its functionality? And depending on what it does, maybe there is something patentable there. So it's a bit of a grey area, but there certainly are elements of computer games that are patentable. Okay. So here are a couple of examples of what might be patentable, what might not be in relation to a computer game. So on the left, we have a reduction in communication overhead. The simplest way to kind of think about things is probably low-level developments are more likely to be patentable than higher level. So things that, for example, make use of less power or save memory, speed up communication, and maybe offer quicker rendering of graphics, for example. Those type of things are technical problems. And if you can come up with a technical solution to that in developing a game, then potentially that's patentable. On the flip side, we have things that are not patentable, which are generally at a more higher level of how the game operates. So things like changing viewing settings are unlikely to be patentable. And one way to think about it is if you were trying to implement a game feature, if you could simply tell a software developer this is what you want the game to do, and they can go away and very easily write the code and be able to implement that, that's probably not something that's patentable. But if there's actually a technical difficulty in being able to get your game to do what you want it to do, then maybe there's a technical problem and it's a technical solution that comes from that, and that potentially is patentable. Okay? Okay, so leaving patents for now and just taking a quick look at what designs might cover. Really, design protection relates to the look of something as opposed to its functionality. So there are a few examples listed there of relevant things where you may be able to get a registered design protection. And the example shown is actually not of a computer game, but a trunky, which is a child's ride-on suitcase, and it was quite a well-known case in the world of IP a few years back. But it's quite a good example to give a visual indication of the scope of a design protection, because through designs you can't get protection for a concept. So the fact that these are both ride-on suitcases doesn't matter. Really, what a court would look at if they were looking at infringement would be how similar are they? And they don't need to be identical in order for infringement to occur, but they have to create what is called the same overall impression. And that's a bit difficult to decide what that really means. But effectively, it means that by changing some of the design elements, so even though both of them, for example, have ears on these suitcases, the ears themselves actually have been designed differently, and they have been deemed that actually overall every feature, although they both include similar features, they're actually all designed slightly differently, and because of that it was deemed that they actually create a different overall impression. So the register design is actually the one on the left, the grayscale image, and the one on the right is the infringer or potential infringer. And in that case, there was deemed no infringement because the designs were deemed to be sufficiently different. Okay.
Thank you, Pam. I'll pick up with copyright. So copyright is an unregistered right in the UK and the European Union that arises automatically when one of the types of works that is protected by copyright is created by an author and recorded in some shape or form. So rather than to go through all the different types of possible copyright works that computer games include potentially, we focused on a few of these in the list in front of you now, and I'll just run through them quickly just to explain how copyright would arise in these instances. So we mentioned software right off the start, and we briefly, Pam briefly spoke about a possible technical solution to a problem that could be patentable. So a software patent could come about. Another aspect is the actual code and the way that it is written. So the actual written expression in the programming language will also function as a written or a literary work, and copyright will be attributable to it. So it will arise automatically once it is recorded, and there will be a measure of protection potentially there. However, in terms of computer games and programming languages, one thing to keep in mind is that a lot of expressions used in programming languages tend to be standard, and there are only certain ways, certain aspects of the program or can be encoded, or certain functions within the program can be achieved. So it really comes down to whether a substantial part has been copied from a written code or not. But we'll touch upon that a little bit later as well. James has got some excellent examples regarding that. So the next thing up is films and animations. Your computer game might include, for example, a recorded animated video sequence, or it might include, say, a filmed clip. These are also types of works that copyright arises in. It arises in respect of the dialogue, if there is any, in respect of, say, if there's acting involved, if there's choreography involved, as a dramatic work, and also in the recording itself. So there are multiple layers of copyright there, potentially, relating to films and animations on their own. And these are possibly neatly packaged in a computer game. And there will be other types of copyright works in the game. So for example, music, again, it is a type of creative work that will have copyright arising in both the recording and the notation, for example, of the piece of music. A website used by a computer game company will have images, possibly sounds, possibly video clips on it. So again, and text as well used on the website will have some form of copyright arising in it. Again, the question will be, to what extent is it original? Is it protectable? Is it the author's own intellectual creation, which is really the core of where copyright stems from, the author's own intellectual creation. Similarly, marketing literature and advertisements can include pieces of written work. They can include images. These can be photographs of drawn images, and these may have copyright arising in them. So one example would be if you've got stock photos, it would be advisable to find out whether or not these are actually free for all to use, or if there is a license fee associated with the use of such images. So if we move forward, that takes care of copyright, and we'll move on to trademarks. So the very first aspect in relation to trademarks that we'll look at is the sort of more traditional forms of trademarks that you'll see, which are trademarks protecting specific names, so word marks without any stylization, and then trademarks protecting specific logos and images. So trademark, really, what it boils down to is an indication of commercial origin, or the badge of origin that one business or undertaking is able to distinguish its goods and services from that of another. So we've got a few examples here of studio names and game names, and as you will see, all of these are stylized. They have little logo elements to them. So just to break it down, a company might want to seek protection in the name that is included in the company name. So, for example, Brace Yourself Games, they might want to seek a trademark registration for the word mark. They might want to seek a trademark registration for the logo on the left, so the blue diamond with a little smiley face, stylized smiley face in there. Or they might want to seek a registration for the combination of both of these as a single registration. There are benefits to seeking protection only for the words themselves, because that enables the owner of the trademark to use it in various stylistic fonts and various styles as part of, say, a wider logo. And there's also benefits to seeking a registration of the logo element, because that will enable the owner of such a trademark to then use that logo element on its own without having to refer to their company name. And this can really stick out in the minds of the consumers potentially. So, for example, the prancing horse for Ferrari is a badge of origin that doesn't need the name Ferrari next to it. Yeah, so we'll move forward and we'll look at computer game characters. So we've highlighted here in the 4 boxes the 3 different categories of intellectual property rights that would apply to computer game characters, potentially, and the types of protection that could be sought in say an image or the persona of a computer game character. We move forward slightly. We've got the example of a 2D trademark registration before the European Union Trademark Office, Intellectual Property Office, and this covers the 28 member states of the European Union, and it is for a 2D drawing of the game character Mario. So the substance of this trademark registration is that image on its own, that one view, but the registration gives the owner of the trademark the sole right to use that image. And when it comes to trademarks, Pam mentioned previously, when it comes to designs, the test that is applied is that of does it create a different overall impression on the informed user. When it comes to trademarks, it is the question in relation to a potentially infringing mark is whether or not there is a likelihood of confusion arising from the trademark if it's used in respect of similar goods. There's also another layer which stems from a trademark having a reputation, but that goes slightly beyond the scope of this presentation. So this is one example of how a computer game character could be protected. Another example is a 3D character model from Little Big Planet. As you can see here, there are multiple views, and these are all included in the trademark registration. Again, it is a European Union trademark registration, and the 6 views, the presence of the 6 views is in order to protect the 3D shape of this character model, and to enable the owner of the trademark to refer to this character as a badge of origin. So again, another example of how a computer game character has been protected with intellectual property. One of the things that we mentioned previously, so the different categories that come into play with designs and copyright. So there will be copyright arising automatically from the creation of the 2D image of Mario and the sort of ragdoll character, be it in a 3D format or a 2D format. And here we've got something a little bit more interesting. We've got a motion mark. So a motion mark is essentially what you can see before you. It is a character or say a group of symbols. It could be geometric objects. It could be lines interacting in some way and creating a motion and that is the core of the substance of the motion mark. And the motion mark is a sort of a slightly newer category of trademarks, and it's something that might become even more relevant when it comes to computer games in the future. I'm not sure if you've heard about this, but there was a scandal or a few court cases actually in the US involving dance steps or sort of choreographic routines adopted by Epic Games in Fortnite for various characters. And these choreographic routines, or these little dance steps, dance moves, had been basically thought up, created by, and were very recognizably, or the intellectual creation of various artists, pop artists and actors. So as far as I'm aware, a lot of these cases have now been withdrawn. Maybe there's been some form of settlement out of court, I'm not sure, but this essentially seems like a category where motion marks could be really relevant. If your computer game character does a quirky move, or you know, it's some form of dance routine. James has just made our character jump up and do a little spin. Something like that could potentially be protected by a motion mark. We move ahead. So computer game environments, and we've highlighted designs and copyright here as well. And when we talk about environments, what we really mean is the manifestation of the game world that the character is set in. So this could be in 2D, or it could be in 3D, and there will be various aspects of that world that could potentially be protected via designs, via registered designs, for example, or that could have protection arising automatically via copyright. So, for example, if various images have been combined, say to make up a game world, artists have developed 3D models of trees, rocks, say a castle. All of this will have some form of copyright arising in it, as well as the ordering of these different objects on a computer level, or a map that may also be protected by different types of intellectual property. So, for example, designs. So if we move forward by a step, here we have an example of a design registration. So this is really for this type of layout on the home screen for the me. So yeah, move forward. That's part done.
Hello again. So this next section is all about protecting your code. So one thing you may have noticed throughout the presentation is anytime the character enters a new level, a little pop-up comes with player 1, 2, or 3, and a lovely image of one of our faces. And I just want to quickly make sure that we're all on the same page for what I mean by code. So this is the code in the game that actually controls that. So it loads the correct person's face, be Pam or Eric. It updates the number accordingly, and it plays the little flashing animation. So this is what I really mean by code. And going back to the game, code can be protected with patents, and it can be protected with copyright. So Eric's done a really good job of explaining copyright. So the only thing I'll add is that a way to detect third-party infringement potentially more easily is by adding lines of redundant code or comments. And that way, if you can see an infringer has those lines of redundant code and comments, it's much easier to prove that it came from you. Concerning patents, I want to talk about two different flavors of patents, categories that I have kind of created. Unlike copyright, patents protect the function, but not the expression of an idea. So the first kind of function that I want to talk about is kind of low-level function, for a kind of low-level pattern. So these protect things like how a graphics card renders frames, or any clever networking stack improvements. So this might be to reduce latency in a multiplayer game, that kind of thing. And the example that I have on the screen is a patent application from NVIDIA, and they make graphics cards, or it's actually a granted patent. And this patent is all about efficiently and accurately simulating many particle systems or many body systems. And this could be done for visual effects, such as for fluid flow. And that's what the image on this slide is showing. It's unfortunately a slightly low quality image. A lot of patent images are, and this came from the patent itself. Or alternatively, it could be used for simulating rigid bodies or clothing or hair on a character, that kind of thing. So this particular code was all about making these many body systems be simulated much more efficiently. And it's the kind of thing that would be developed by someone developing a game engine, or maybe someone developing video card drivers, or drivers for CPUs or graphics cards, a company like ARM or Intel or AMD or anyone like that. The second type of code that I'd like to talk about is what I would call a high-level pattern. So this is still a technical solution to a technical problem, but it's much more likely to be contributed by a game developer. So the particular example I have here is from the Pokemon franchise, and the technical problem was to do with generating unpredictable Pokemon encounters. So it's much more fun if you have no idea what Pokemon you're going to encounter next. But the way that they wanted to achieve this, and the way this was written in the patent application, was to use the time of in-game day, so if it's nighttime in the game, or if it's morning or whatever, and also the input from a random number generator. And this was deemed patentable because it was a technical solution to a technical problem, and was otherwise eligible. So there are two main things to learn from this second patentable code example. So first, patenting software, and in particular video game code, is absolutely possible. And second, whoever drafted this patent was completely unaware of type advantages in Pokemon. Butterfree versus Venusaur is not a good matchup at all. So next, I would like to talk about user interfaces. User interfaces are interesting because, at least in theory, and depending on how you define them, they can be protected by patents, trademarks, designs, and copyright. So just to give you an example of what I mean by user interface, there's the IP skill bar up at the top, there's the IP value, and there's also these little player 1, 2, 3 things that I keep showing. So my first graphical user interface example is protected by a patent. So this is from a footy game, and it relates to displaying little marks around players' feet to draw the user's attention to that area. And it was deemed patentable because it was solving a technical problem again. And this technical problem was the conflict between the display size and the information that can be shown on the display. So if you have a really wide field of view, for instance, if the gamer was able to see the whole footy field, the information would be really small on it, so it would be difficult to see things. But if the field of view is really small, it's really easy to see individual things, but there's not much information there because you're so zoomed in. And this patent was all about resolving this conflict, and so it was deemed patentable. The next example, it's a bit of a double whammy. So at the bottom, we have a graphical user interface from The Sims, and there's points to anyone in the chat who can say exactly which Sims game this is, Sims 1, 2, 3, the herbs, or whatever. And on the right, there is a registered European trademark. So the diamond trademark is quite interesting because there will be copyright in this work, but it's also a graphical user interface element because this is your cursor in the game. And as well as that, it's widely used in the promotion of the game. So just here, we have a first summary table. So this is about the kinds of aspects of a game that can be protected by the different IP rights. This table isn't meant to be completely definitive, but be a bit more of a guide, and it shows that certain elements, such as the characters, can be protected by a wide range of rights. So here it's shown trademarks, registered designs, and copyright. But certain aspects of the game, like the character dialogue, are only protectable by one right, and that is copyright. So the second quick summary slide is just shown here. And this is to show that the protection period for the different types of right is quite variable. So patents is relatively short at 20 years, although in a fast-moving industry like for video games, this can still be quite a good length of protection. There's copyright, which is the death of the author plus 70 years. So this is quite a long period. And then trademarks can be renewed indefinitely, as long as they are renewed. And this is another feature that's shown in the center of the table, where patents have to be renewed every year, but copyright, for instance, doesn't need to be renewed at all. Finally, there's the other requirements. So you've got things like a patent, which it needs to be inventive as a requirement, whereas with copyright, it only needs to be original. And then trademarks are interesting because they are a badge of origin, and this is a little different to the other types of rights. So we're now on to the final level. So on this level, I want to first acknowledge Pixel Frog. So I didn't generate all of the art for this game. I generated some of it, but I'm not a particularly artistic person. And so I'm extremely grateful that there are people out there like Pixel Frog who are excellent artists who can make little characters like the one we've been using today in the background and so on, and make that free of use. So I just wanted to acknowledge Pixel Frog. And then this is our contact details. So there's myself in the center, Pam at the top, and Eric at the bottom. And this is our address in Edinburgh. If you come along there at the moment, unfortunately, we won't be there because we're all working from home. But if you have any questions or you'd like to get in touch, please just email us, and the slides are attached. So that might be an easier way to find our emails. And finally, I'd just like to move on to this last slide. So this is a kind of summary showing some of the key points that we have gone over to prompt questions. So if you have any questions, we'd be absolutely delighted to answer them. Yeah, we'll just open the floor for that now.
And just one more thing from me before we move on to questions. Just I wanted to summarize. Hopefully, we have demonstrated that computer games have a lot of different aspects that could be protected by different types of intellectual property. It is a growing industry. It is a massive industry already, and it is really important to think about these IP rights in advance, especially taking into consideration possible ideas for as my colleagues mentioned previously, for example, collaborations or say merchandising of various say items based on IP found in the computer games.
Yeah, and I don't think I've noticed anything, so we'll maybe wait just a few seconds, and after that we have some questions of our own for ourselves that we can use either in addition to audience questions or in place of.
Maybe James, you could just start with the first question that we had thought of, and in the meantime, if any more come in, we can address those after.
Yeah, that's a good idea. So the first question I want to ask is to you, Pam. Are there any issues concerning contracting development of your game out to third parties, things that game developers should be aware of?
Yes, so I guess the main thing to be aware of when using third parties to develop aspects of a game or aspects of anything for that matter is ownership in terms of IP and who actually owns the rights to the images, to the code, to any innovations and patents that might arise. So really the main take home would be to be aware of ownership. Check what the contract actually covers, who actually owns the rights at the end of the collaboration, and if necessary, execute assignment documents so that the IP ends up being cleanly assigned to whoever it is agreed should own it going forward, and that will save a lot of heartache potentially later on when these kind of things can come to light and cause issues.
And do you have to worry about similar issues if someone is your employee, or is that simpler?
Well, certainly under UK law, normally if it's a task that's part of your day job, as it were, then normally IP would be automatically owned by the employer if you do it in the course of your employment. It does become more difficult if in other countries that there are different requirements and different rules, so it would be worth checking whatever is the relevant case. But yeah, normally in the UK anyway, employment would mean that the rights would automatically be owned by your employer. But it does depend as well on whether you do it as part of your normal day job or whether it's something you do kind of on the side. If it's just a hobby that you do in your spare time and it's nothing to do with your employment, then potentially that would be your own IP.
Right, thanks. And we've had a couple of really good questions actually. So the first one, I might address, like split it up and address it partly to you, Pam, and partly to Eric. Maybe with trademark and copyright from you, Eric, and the designs and patents from Pam. And I'll ask Pam first. Is there a way to check if something has like a copyright or a design right, or there's a patent for a particular right? In particular, like online, like if you're a small game developer, is there a place you can look?
There are registers. Copyright in the UK, there's no requirement to register it, so there is no central registry. I mean, some companies do offer a register, but they are unofficial and as a result incomplete because nobody's obliged to use them. So for copyright, the answer would be there's no easy register to look up, although in other countries that may be different. For patents, they are registered and they are published, and you can look at those online and they are freely available. The difficulty is that they are only published usually after 18 months from when they are first filed. So there is always a period when a new patent application has been filed and the general public are not able to access that. It is still kept secret for that first 18 months. So it is possible to do searching and to find out if people have published patents, but you should also be aware that they may also have other patents which have not yet been published. So it's never going to be definitive as to what any company has at any point in time.
Mm-hmm. Yeah, and I guess just to add like a tiny bit, my favorite website for looking up if a patent exists is Fastnet. And I think that's a particularly good resource to search for things, which is hosted by the European Patent Office. And then can I ask Eric the case for trademarks?
Yes, so essentially there are public registers for each territory that trademarks are registrable in. Sometimes these are more difficult to access than other times. In the context of the UK and the European Union, the UK Intellectual Property Office and the EU Intellectual Property Offices have very straightforward online registries that can be accessed. Where it becomes a little bit more difficult is if you're conducting, for example, image searches to see if a particular logo has been trademarked, or if you're looking for combination marks, for example, the registries themselves are not particularly good at identifying relevant results. So a fair bit of skill may be required. So even though they are free to access, the kind of results that you might get doing these types of searches on your own might be quite limited, and they might not reflect the whole picture. One thing to also consider is, we previously mentioned that there are unregistered trademark rights, potentially that have been accrued through use of a sign or name or a logo in the course of business, and these wouldn't be reflected on the registries. So from a trademark attorney's point of view, we would always recommend conducting clearance searches before adopting a name for, say, a game or a computer game character, or a particular logo before, before that trademark is essentially adopted and made public, just to make sure that there aren't people out there with earlier rights. It's also worthwhile to mention, as I noted before, with trademarks, the test for potential infringement is a likelihood of confusion. And again, that involves searching for trademarks that are similar or potentially could be considered similar. So again, a little bit more sophistication there than what you would get from just looking at the registry on your own, generally.
Thank you very much for the answer. Yeah, and I guess it's also a thing that we're able to help you with, freedom to operate searches. So that's worth mentioning. The next question, the second question that I'll just ask you both, maybe Pam first and then Eric to add a little bit at the end again. So cloning is relatively commonplace in games. How can a small studio realistically defend a patent or other intellectual property rights against a large company? Because I'd be thinking of the Intellectual Property Enterprise Court, but is there anything else that you'd like to add?
Well, yes, I mean, there are, in the UK and I think in other countries as well, there are systems that are set up specifically for smaller companies to try to lower the burden and lower the cost in terms of litigation for things like patents and other intellectual property. So it's called the Enterprise Court in the UK, but there are similar things, I think, in other countries. But it can be expensive. There's no good answer, I guess, to the question. It's a difficult one. I suppose one thing to bear in mind is, though, that patent litigation really is a last resort in most cases. You know, there usually is a long process that builds up to litigation and the court case in the end, and it's quite uncommon actually that patents get that far and actually end up in court. Most of the time, if there is some kind of dispute, it's usually settled way before it actually ends up in court. And there are things like mediation and arbitration that can be involved to reach some kind of settlements before it goes too far. So I would say, yes, it's a good point. It is difficult. It is most likely going to be expensive, even if you use some of these lower cost kind of court procedures. But there are other advantages of IP as well. You know, like James highlighted in the first slide, it's not all about getting to court and you know, suing someone for infringement. There might be advantages. You might be able to enter into a deal or a negotiation with the other party, maybe on a licensing basis, and avoid such extreme measures. Would you have anything to add, Eric?
Just from my point of view, to add a trademarks perspective. So generally, the way the trademark system works is it is sort of on a first come, first served basis. So if you get your earlier registration date in, or well, you get your application in, and that secures your filing date, which is essentially the date that your rights arise from once the trademark becomes registered, then that is normally the sort of start of your rights, and if anyone else then tries to use a similar trademark or an identical trademark after that, then you've got a basis to challenge them on that. Either, say, if they apply for a similar or an identical trademark, it is possible to oppose that application. There is a sort of fixed schedule of fees and costs in terms of what potential damages or cost awards might be awarded in these types of proceedings. That's one thing to consider. So in terms of also the filing date, I did mention it's sort of first come, first served, but there are aspects there. So for example, if you've got the situation where you've say you've got a game that you've been developing for a while, you've kept the name and the names of the characters under wraps, and say that leaks out somehow, say there's an employee who goes AWOL and decides that they want to register the names in their own name for whatever reason. There are other aspects in intellectual property law, such as opposing a trademark application on the basis that it's been filed in bad faith. So there are various options there. Again, how costly it will be at the end of the day will largely depend on the substance of the case. It might be quite straightforward and the costs will be lower, or it might be quite a bit more complex and the costs could be higher.
Thank you for these questions, by the way, and also the answers. These have been excellent questions. So the third question is from a game developer, and it's great to have game developers here. And they say they are developing an educational game and they want to use real images in the game. They plan on purchasing them or getting the user's permission, presumably the person who created the image is positioned, but what if they can't reach them? Can they just acknowledge them and say that they don't own the image themselves? And you can always take the image out if someone complains, but ideally you wouldn't want to take any risks, and this is what they're saying. So the first thing that I would mention for this is an image repository that I've used for a while called Pixabay, P-I-X-A-B-A-Y, and they do royalty-free images, and they're also free images themselves. So if you're just looking for images, it's an excellent place to start looking. I guess the rest of the question is a kind of contracting question. Is there anything you'd like to add, Pam and Eric?
I think on this one, you know, the question almost says what we would say, in that yes, you should try and, you know, seek permission to use any images that are not your own creation. Where you can't do that, then it's a judgment call. It is a question of whether you think it's worth using based on a potential risk that someone could object to it, and really in practice, how big is that risk? And it would depend on the circumstances, really. But certainly, you know, your thought process is absolutely correct. You know, try and get permission. Even if you can't get permission, I would log the steps that you've taken to try to identify who owns it, so that you know, if it ever did become a question, you know, someone did challenge it, you could produce evidence to say, well, I did try and do the right thing. You know, I did try and contact them, and that would probably help in your favor if it did cause an issue. But yeah, it is a question of risk, and how much risk do you really think that would be, and do you know, are you willing to take that risk, or is it simply better to use other images that you can get permission for, or create your own, for example?
And from my point of view, the Copyright Designs Patents Act is a fairly extensive piece of legislation. What it does have in it is certain permitted acts and permitted purposes when it comes to copyright. So educational purposes, well, in principle, are one category, that do fall within the sort of permitted purpose exclusions when it comes to copyright. However, it really gets quite complex because you need to have only used what is necessary for your educational purpose and not anything more, and then that really requires a legal assessment on a sort of case-by-case basis. But there are options in the legislation itself in terms of educational purposes.
I think as well, though, that would have to be considered in view of what commercial objectives there are as well. You know, although it's for education, if you're selling an educational program, then that's a commercial activity as well as being educational. And I think again, those things would need to be taken into account. So it's not clear cut, unfortunately.
Yeah, presumably it's best to err on the side of caution, though.
Well,
and then,
yeah, but well, either err on the side of caution or make an assessment, you know, a proper assessment of the risk, seeking advice if you need to on what that risk is and how to quantify that, and then making a judgment call on whether you're willing to accept that risk or not. You know, most things have a risk attached to them. It's just a question of what are we willing to tolerate? Do we want to take on that risk or not?
And I guess the same applies for music and videos and other things as well.
Yeah, absolutely.
I think these next two might be predominantly for you, Eric. So the fourth question is, to the extent that a game also leads to lucrative merchandise, what additional factors, if any, should you consider from an intellectual property perspective?
Yeah, sure. So in terms of merchandising, well, from the context, from the point of view of trademarks, for example, if you've got certain logos or certain character images or certain words that you wish to have ownership of and wish to control the merchandising rights for, then you would certainly need to think about potentially securing trademark registrations for these types of intellectual property. And then another aspect to consider is that the trademark applications and hopefully in the future registrations actually cover your goods and services of interest. So one thing I would recommend is being forward thinking. So if one would say create a computer game and seek a protection for a trademark in relation to that computer game, then you might, for example, seek a registration in Class 9, which covers computer software. But then if you're thinking about merchandising and say you wish to start selling T-shirts, you would also want to include in that potentially the initial registration also Class 25 covering various articles of clothing. So it's really something to be forward thinking about and to try and secure registered rights in. The next aspect then is basically making use of those registered rights, for example, via a licensing agreement. So allowing, say, a third party to have access to your intellectual property and use it to then say manufacture. Say we've got on the slide here, we've got that little character in 3D to make use of a license allowing them to manufacture those dolls and then market them, or for yourself for that matter. One thing to keep in mind though is that a license agreement is best written down rather than in a sort of word-to-mouth kind of an oral agreement, and there are lots of different factors to consider. But certainly trying to secure registered rights and then making full use of them in order to then further your wider business interests is the recommended route to take.
Thanks. We're I think we've actually gone longer than we were expecting to go on for. I think, well, we've only got one question left, so I'd be perfectly happy to finish this question and wrap up after that. If people think that's kind of okay. So this one would be another one for you, I think, Eric. Is there any indication of what will happen to UK companies who have registered EU community trademarks previously after Brexit has happened? And will they have to re-register them again to trademark in the UK?
Yes, so in terms of Brexit, this has been worked out by the UK Intellectual Property Office and the European instances as well. The current state of affairs is that when the transition period ends on the 31st of December, any registered EU trademarks will be automatically cloned over to the UK register. So essentially, the owners of existing European Union trademarks will get comparable rights in the UK, and the process is automatic. There are certain things to consider there. For example, if your European Union trademark is coming up for renewal, and the renewal date is, say, after the 31st of December, then your comparable UK trademark will also have to be renewed separately, even though you may have renewed the European trademark. Another thing to consider is that this only applies to registered trademarks in the European Union. It does not apply to European Union trademark applications. However, the UK Intellectual Property Office does allow a sort of priority claim of 9 months to then refile an application claiming back the original filing dates of the European Union trademark, but then full fees would be applicable. One other thing to consider when talking about the cloned rights or comparable rights is that all of the information from the European trademark, so the ownership information and representation information, will be copied over. And this could lead to instances, for example, where the representatives on file are, say, Spanish trademark attorneys who are maybe not best suited to handle UK trademark matters. So something to keep in mind.
Okay, so I think I'll wrap up at this point. So I'd like to thank everyone who came for coming. I would like to thank Rachel first, who has made sure everything went behind the scenes smoothly, did all the signing up of people, and has been generally in the background making sure everything works, doing the advertising and so on. I'd also like to thank all of our panelists, Pam and Eric, and probably most of all, the audience. Thank you so much for coming. Hopefully you've enjoyed this presentation. And if there's anything that you feel we can help you with, we'd be absolutely delighted to do that. Just drop us an email or phone us or whatever it is. So thank you very much for your time.
Thanks, James. Thanks to you as well.
Thank you.
Bye, everyone.